Mm. Okay. Hi, Dr. Gudiel. Thanks. Yes, good to see you there.
Yeah. Can you hear me?
Yeah. If something happens again, take over and then continue, moderate the session, please.
All right.
Okay.
We are live.
Oh, okay.
Good luck.
Good luck. Start now. Yeah. Hello and welcome to the this webinar. The Center for Legal Pluralism and Indigenous Law, Faculty of Law, and the Dayak Cultural Foundation is very pleased to welcome you to join this webinar on reflections on the Director of Forest and Tuaruma Sandah, customs and usage having the force of law. Because of the overwhelming response to this webinar, we are able only to have 100 people in the Zoom call. But this can also be viewed and followed through Facebook, which I hope has been sent to you also, so that as many of us can follow the discussion. Let me just say at the outset that the discussions will be recorded, and after this, it will be available at the Faculty of Law website, which you can go back and have a look at. And if you have any questions on this, as we go in this webinar, please use the question and answer box, not the chat box, the question and answer box to ask your questions. We will try to get the speakers to answer as many of the questions as possible, but if we can't answer all, we will get back to you later. We hope to do a summary report of the sessions and give you the slides with the consent of the speakers and send them to the registered speakers, the registered attendees rather. Right. Now, it's great to know that this topic has generated such an interest. It goes to show that this concerns so many of us. Our registered attendees comprise a wide spectrum of people, from law students to academicians to lawyers, both government lawyers and corporate lawyers, judges, both serving and retired judges, government administrators, NGOs, representatives of ethnic associations, politicians, and other individuals, including businessmen and others. So I want to thank the speakers for agreeing to come on board. Just very briefly, I want to introduce them. Tan Sri Richard Melanjun really needs no introduction. We all know Tan Sri. He just retired as the Federal Court Judge and as the Chief Justice of Malaysia. Tan Sri Melanjun has given many cutting-edge and outstanding judgments, which when he was on the bench, we are so pleased to welcome him to join us on this webinar. The second speaker will be Dr. Yogeswaran Subramaniam. He specializes in indigenous land rights with a specific, with particular focus on Orang Asli. He's acted on a number of significant cases, including the appeal on this particular case that we're looking at. Dr. Yogesh has written quite extensively in this area of law in local as well as international journals. Then we have Dr. Gudiel Singh, who was formerly a professor with us at the law faculty. He now practices law and is president of the National Human Rights Society, HAKAM. Dr. Gudiel, I think, has a very long-standing interest in indigenous land rights or indigenous people's community and communities in Malaysia. He was among the earliest lawyers involved in these issues. As some of you may remember, he was the lawyer in the Kajing Tubik's case, which was about the Bakun Dam. He went on to do a lot of work on diversity and biosafety law. In fact, he was involved in courses in biodiversity and biosafety law at the faculty, and very much involved in negotiation for the government on other matters, including the Nagoya Protocol. He's got many publications, but I just mentioned this one, which I think relates to things that we are talking about. This book on In Defense of Local Community Knowledge and Biodiversity, a conceptual framework and essential elements of a rights regime. So we have speakers who really know this subject, and I hope that you will really benefit from these talks. I will can I have just one the next slide just quickly? Right, this is basically what we'll be looking at. We're looking at the legal pluralism system in Malaysian legal system. As you know, our legal system is both in Article 160, law includes written law, common law, and customs and usage having the force of law. And I think it's in indigenous land rights that we see the coming together of these sources of law. Next. Right, so these are sources of customary title or aboriginal title. As you can see, it is very much reflects the definition of law in this country. Next. Right, so very briefly, the facts of the case, I will just run over this very quickly for those who do not know. Most of us, I think, who registered for this really actually know the facts of the case, but this involves the provisional lease that the state of Sarawak had granted to Rose Bay Enterprise. The Court of Appeal recognized and granted rights to the native claimants, but this was appealed to the federal court, where the states of Sarawak and Director of Forests basically challenged the grant of NCR to these people because it was in uncleared and uncultivated areas. And next. Just very quickly, I'll just, the Ibans were claiming their rights over those areas based on their customs of Pamakai Manua and their Pulau, which forms part of their traditional territory. Now, this, normally what is recognized, have always been recognized, is the Tumudak, but the Pulau and the Pamakai Manua are not expressly referred to in the Sarawak Land Code and any other legislation. Just quickly, the next. So questions that were raised, I think it's just very quickly to go over this. At the federal court, the question was whether NCR is recognized by common law and includes rights to forage in primary forests that were left uncultivated. And I think this is the primary thing. Is this sufficient to as a basis for NCR in Sarawak, especially when it is not, let's say, where it is not, you have not seen it in some statutory instruments. Okay. So the question that we are looking at is basically, what then is the basis of claim that the indigenous peoples are asking? Can they use customs as a basis of claim? All right, next one. I think we need to just look at this because the majority decision didn't question the existence of the custom. They did say, yes, there is such a custom, but he says it does not have a force of law as envisaged by Article 160. And he also said, or they also said, the pre-existing rights do not include rights to primary forest. So this becomes the issue. Can we look at the next slide, please? So we want to cover these issues. Basically, what exactly do we mean by custom and usage having the force of law? How do we interpret this in the federal constitution? Are indigenous customs basic, or rather, can they be sources of law in their own right as a basis for native customary rights? And then we will look also at the common law principles, which principles on native customary rights, and later on at indigenous traditions. What's the interface between indigenous traditions, statutory provisions, and then the place of native customary rights? So each of the speakers will be dealing with this. Okay, I think that's the last slide. Any more? One more slide. All right. So with that, that's just an introduction to the case and some of the things that we were hoping to touch on. I know there are some other issues that have cropped up, but I think these are the major ones that we'll be looking at today. So with that, I would like to call upon Tan Sri Richard Melanjan first to speak on the interpretation of and the meaning of law, what is meant by custom and usage. I think this is something that we really need to address. Thank you, Tan Sri.
All right. Thank you, Prof. And good afternoon to everyone. It's a pleasure to be in this webinar. And I know that this is afternoon. Some of us may be taking a siesta, especially those who have retired, but never mind. Let's go on with this subject. So I have the the PowerPoint on the screen, I think. Could I have the next one, please? All right. This will be roughly the content of what I intend to cover. This is a quick one, basically only on 3 matters. Yeah. Okay. Next, please. I have to rush a little bit because we have very limited time, I think. All right. Prof. Remy has covered the TR quickly just now, majority and minority judgment. And you can see from the slide, I have actually highlighted having the force of law. What do you mean? What are the expectations under this? What does the court expect for others or for us to do this as lawyers? Yeah. And what's the legal implication of the 2018 amendment? I put that in as well. And I put a question mark there, whether that amendment itself, yeah, may be in breach of Article 13 of the Federal Constitution. I will then expand this later on, why I think that it might be a infringement. Next slide, please. Next slide, please. Next slide. Yeah, all right. Of course, we all know that sources of law in Malaysia, Article 1602 of the Federal Constitution say that. And the last part is that we are interested in, yeah, custom and usage, the force of law. Now, before going further, this is what I intend to, I propose to show to everyone, yeah, what the judge should do when looking at the law. And I got it from what Mr. Dr. Gopal Sriram said when he was still the judge. And he said this, yeah, judges should address the needs of society, quite differently structured. In other words, we have to look at it as the need of the society. And in this case, we have to look at the natives of Sabah and Sarawak with different aspirations and so forth, yeah, entirely different set of values. So we can't expect somebody outside to understand us, the natives, if they don't understand even how we live. I think that must be in the head of the judges before they came up with certain pronouncement on the rights and interests of the native. And I think we have to take pride on what Gopal have said in Hong Leong. Okay, next slide, please. Now, having the force of law, I put it here, whose function is to give custom having the force of law? Whose function? Put another question. Is it the court, legislation, executive? If it's the court, is it not a factual thing to find out whether a custom has been established, whether it's reasonable, and whether therefore it has become a part of law? And one accepted, can the court revisit it?
What is force of law?
If revisited, what happened? If revisited, what is the legal implications? Right. Now, in my view, custom need to be given a judicial notice by the court in order to give it the force of law. It is part of the function of the courts. Of course, sometimes it is legislated through legislation, sometimes even by executive order. This has been seen during the Brooks time in Sarawak. Now, therefore, when you are giving custom the force of law, and then therefore it's part of the function of the court to see to it that it has the force of law. The court should not expect legislation for the custom before it can be said to having the force of law. That's how I look at it when it comes to the use of custom. And you know why I say this? Next slide, please. Next slide. Look at that. These examples were custom given the force of law through judicial notice. Yeah, BC Jinggot, and these are customary marriages and so forth. Robert Elias. I will not go each one of them because we have 10-15 minutes time to present. Next slide, please. And there you are. These are all examples of cases decided by our courts here, where judicial notice is given to the custom and then enforced by the courts. In other words, the court then recognizes the existence of the custom and then give it the force of law. We should be looking at that from that aspect, is it not? So these are some of the cases that have been decided, and you can see that most of the time, sometimes the judges will first instance will call for evidence to see whether those customs satisfy the requirement to be considered it as part of the law of the society, reasonableness, and not against public policy and so forth. Is it not? Those are the ingredients of a custom to be before it can be taken as a good law or possibly a law for the society. Next slide, please. Now, origin or native customary rights. It's all here for this is in reference to Sarawak, yeah. And I put that slightly, Raja Brooks, James Brooks, land regulation, food trees order. Next slide. I go quickly on this thing and look at the 1951 amendment as well. It's all related to the NCR or native land. Next slide, please. 50th amendment. This I go quickly to this one. It's all available in as a legislation. Where this is the way the executive, I think at that time, recognized the existence of native customary rights. Next slide. There you are. Then 58, of course, there has been replaced. The 1958 Land Court replaced all these other rules, other legislation or orders. Next, please. Next slide. Right. I will start first with this case. I think this is the origin of the whole problem in TR Sandah. Nyawai case. This is the High Court decision. Now, I have underscored those statements that to me I find is relevant. Yeah, dispute area within FSS and share this, and then the court concluded the pre-existing rights. Okay, this pronouncement by High Court in Nyawai seems to have been accepted by in TR Sandah by the Federal Court. Next slide, please. And it went on further. Extinguishment and that it cannot be simply be removed. All this seems to have been accepted by the Federal Court and even by subsequent Federal Court. Yeah, it cannot simply be extinguished and so forth. So in other words, it does exist. Native rights on native land, customary land, actually it's there, and that is not in dispute. Next one. Next slide, please. Right. Of course, it went up to the Court of Appeal in Nyawai, and it was very much basically on evidence, inefficiency of evidence, at the time. It's not so much whether the High Court was wrong in the law, It was very much on insufficient evidence. And you can see that no doubt that the Court of Appeal in that case also opined that occupation at the settlement may be beyond the protection. But let's look at the next steps on that issue. This is where actually the problem started, is it not? Occupation and so forth. And they said that the custom of connected to Pemakai Menua and Pulau is not good enough. Next slide, please. And look at that. The way the Court of Appeal actually accepted whatever had been said by the High Court in Nyawai. Yeah? So we have to be clear on that. Nyawai actually did not overturn the High Court decision, especially on the findings on NCR and so forth, but actually it has affirmed, except on the basis that the High Court judge may not have considered properly the evidence. So it's very much an evidential issue, the difference between the High Court and the Court of Appeal in Nyawai case. That actually should be understood clearly. Next slide. Then Nyawai actually has been, to extent, has been clarified by Madili. That is where Madili actually confirmed that in law in Malaysia, especially in Sarawak, it is recognized, NCR, NCL, and so forth. It is recognized. Okay, so they don't think that is any in dispute anymore. Next slide. Next slide, please. And there you are. The Madili case says to satisfy the occupation, actual possession is not necessary, so long as sufficient measure to control prevent strangers from interfering. This is where the issue is. In Nyawai, it says that, oh, occupation not good enough. But you have to look at Nyawai now through the prism of Madili. And this is where the explanation of what is occupation all about. The question, in my view, is this. If Pemakai Menua and all these things is there's sufficient measure of control to prevent strangers from interfering, definitely that is part of NCR. And therefore, Pemakai Menua is part of NCL, NCR. And that has been established by Madili. Right? So next provision. And next slide, please. Next slide. Yeah, therefore, you see, I put in the context, yeah, Nyawai, Madili, and TR Sandah. Look at that. Nyawai, you really have to think about the facts of the case, you know. Because in Nyawai, there was no dispute, certain area in dispute, and there's another area to say, oh, there is no NCR. The question in that case was, okay, the area that is not being disputed as having NCR, what are the elements there? Yes, all the elements of NCR, including occupation and so forth. So, so if those elements are present in the disputed area, it would have been given the NCR. But unfortunately, the Court of Appeal said that the evidence was not sufficient to show NCR there. So that is the thing that we must keep in mind. On foraging, no doubt, yeah, there was a statement in Nyawai to say that it doesn't include the area of foraging. But then, that was just to express the view in Sagong context, yeah. But therefore, the question is, should area be, as far as eyes can see, it cannot be, is it not? It cannot be. And therefore, Madili, as I said just now, clarified the issue. To satisfy the occupation, there is no need for actually physical presence, so long as there exists sufficient measure of control, prevent strangers from interfering. So if it can be shown, yeah, the Pemakai Menua area and the Pulau where the native can prevent outsiders from coming in and so forth, surely that is part of NCR, NCL. And if that's the case, the law has been established. Yeah. So why is it now that suddenly TR Sandah says, no, we don't recognize that? I find that there seems to have been a conflict, you know, and there was never, if you read the majority judgment in TR Sandah, there was not much an exhaustive discussion on what Madili said, with all due respect. And I think this is where I feel that the TR Sandah could have been per incurrium, the judgment therein, to, in my view, you know, the majority judgment. Because if you look even the minority judgment, it is there, and even the judgment of Abu Sama is in line with what Medley said. So what is there for the position of that judgment, right? Now, in my view, if there is already a right existing, NCR right existing among the natives, owned by the natives, and suddenly there is now this decision, don't you think that it has actually breached the right under Article 13 of the natives? They have actually the right to know this property and suddenly get be removed by one decision of a federal court. This is one issue that we need to look at, I think, carefully. Next slide, please. Then from Medley, even in BC, the federal court there gave an expression of what is pemakai menua, and look at that. Pemakai menua has even been given the description of how you earmark it, where are the boundaries. It's not as far as the eyes can see, right? So this is where that they seem to have omitted all that. And therefore, what is therefore an NCR or NCL? It includes pemakai menua and the pulau. That's how it should have been interpreted, and that has been recognized by Medley. Why is it that suddenly it says, oh, therefore it may be a custom, but it has no force of law? It's up to the court to declare it and give it a judicial notice, which has been given earlier, long before the Sandah. This is the thing that I think we need to examine carefully on the position of the Sandah. Yeah? All right. I've also highlighted some part of it in BC Jinggot case. Next slide. Sorry, I'm running out of time. Yeah. Next slide. Okay. For I say this is a move. This is all the Sandah's judgment. So we discuss. Next slide, please. This is High Court decision. Go ahead, move on. This is a federal court decision. Dissenting judgment. Look at that. All tenets of customary law. Move on some more. Next slide. These are all the dissenting judgment, which I think, with all due respect, is a spot on, if I may say on that. Next one. Next slide, please. There you are. And look at the review case. This is the view of, I think, Tan Sri David Wong on when it comes to review about whether what's the position of the majority judgment and so forth, and the minority, and that's why he wanted it to be reviewed, but of course he did not get the support of the others. Next slide. Okay, and then we are back now to amendment. This amendment, they went very quickly to amend the law, therefore, as if to incorporate or give new meaning to NCR. I don't know whether this was thought of properly, because if NCL has already been properly defined or maybe been described by the federal court in Medley and in BC, is this one really necessary? Why is it that the legislature have to give in to TR Sandah? Don't you think that this piece of amendment has actually curtailed, in a way, the interest of the native? Because under the Medley and even Medley decision, they still have quite an open-ended, but this amendment has given a new direction on how to establish NCR and so forth, when the court has already given it exhaustive discussion. So this is saying, is this right? If I am a native and I have actually a right of NCR over area of land, if I were to follow Medley, and also as discussed in BC, but with this new amendment, don't you think that maybe my right has been curtailed, and therefore my pre-existing right, which Medley said it pre-exists even the statute, has been actually eroded? My right to property, and that to be infringement of Article 13. This is an area, I think, which needs to be looked at carefully, in my view. Yeah, I may be wrong, but in my view, that is an area that has to be looked at. Next, please. Next slide. Next slide. Yeah, all this amendment. evolutionary rights and so forth. This is going to be a subject to a lot of legal discussion and argument in court. I'm quite certain it will happen. And sadly also, this amendment was of course done by the legislature through the executive, prepared it and so forth. But this is my observation. The very argument by the very people or very parties maybe who argued against the existence of the NCR or against the custom of pemakai manual being having the force of law, the same group could have been having involved in this amendment. Now, I don't know whether that is right statement or not, but this amendment should have been approached by some independent experts and so forth. I know there was a committee set up on this, but it could have been good if it has been open for discussion to the public, is it not? And the rights of everybody. Because I really feel that there is this area can still be visited through challenging this amendment, whether actually this is within constitutionally or not. And Article 13 of the Constitution may be an area to look at vis-a-vis this amendment. Yeah. Okay. Next slide, please. Go ahead. These are all amendments. I just produce them quickly. Next slide. Yeah, all these amendments came in. You notice that it really gave a different approach to NCR and NCL after this amendment, in my view. Next slide, please. Okay, that's so much for the NCR. Now I'm going into the Borneo experience. That has been a lot of argument also. Of course, we all know that the source of this idea, it came from the Malaysia Agreement 63 and also in the IGCC, Intergovernmental Committee 1962. The question now is, what is the approach to be taken? The comment from some of the judges, he said, oh, it was never given statutory force, the IGC and the Malaysia Agreement and so forth. And some have even gone to the extent that, oh, it's only a historical document and so forth. With all due respect, I think such thinking or perception is completely wrong. The IGC, the Malaysia Agreement are very important document. In the same way as the judges, the Supreme Court judges in the United States, where they refer to the Declaration of Independence, whenever they are looking at the interpretation of the Constitution. So therefore, these documents are vital. And you know why I say this? Next slide, please. Next slide. Look at that. In Kuruntum, they exactly said what I've said just now. Move on. Next slide. Next slide. Kuruntum was against the idea. And look at that in TR Sandah review provision. And this is what I think the dissenting judge here. Next slide, please. Next slide. There you are, the dissenting judge, again by, I think, that's David Wong, right? The General High Court judge. The meaning of Bornean experience. And you must take into account the spirit of the Malaysia Agreement and the IGC. With all due respect, this is where fellow judges that may not be from East Malaysia, may not have that spirit of what it is like to be covered by the Malaysia Agreement and the IGC. And it may therefore be looked at as pure historical document, but it is not. It is not. It meant a lot to the Borneo territories. And I say this, why? Next slide.
Was it critical in this case, do you think?
Yeah, in a way that, in a way, because they did not, Borneo experience, one of the reasons for the review. Remember there was a review, there was no Bornean experience judge. Yeah. And of course that was actually not given much of a consideration. Next slide. Next slide. There you are. These are all from dissenting view of Tan Sri David. I will not waste my time, but he said that the Kuruntum approach, a simplistic approach, and I agree with him on that. Next slide. You see, even in Muhammad Taufel Mahmud case, yeah, they respected the Malaysia Agreement and the IGC and so forth. So this should have been given the spirit, when interpreting those constitution of Bonian experience. And unfortunately, I think some of our fellow judges before they did not take this seriously. Yeah, Muhammad Taufil made it very clear the relevance of the IGC and the Malaysia Agreement and so forth. Next slide, please. There you are. It's the same decision here. Yeah? In fact, the Tun Zaki was very strong on this case. Next slide, please. Then, even in the case of Sugumat Bakosa, this decision was given, I think, by Zaidin. And look at that. They made reference to IGC and the agreement when looking at the interpreting the constitution. So these are things that I think, unfortunately, some judges do not give importance. But I just hope that things will change. Next slide, please. Okay, quality identified spirit right. This is my final slide. Sorry for taking so much time. The constitution must be interpreted in a way that it was the foundation of the country. That's why I've already said it, yeah? And the NCR, as I said just now, has already been recognized as a right to the native of Sabah and Sarawak, and that has been cemented in Madili and in BC. Why? The TR Sandah came and disturbed it or revisited it without much proper consideration is a subject of much discussion, isn't it? And of course, Bonian experience, to me, if indeed you really have to give it a full recognition, then there must be a political will to put it in a statutory form. But I don't know why this country seems to be always looking at statutes before they say it's law, Hopefully, we end up having the rule by law instead of rule of law. I just hope it is not. And it's a duty of the government to protect the state of NCR. And the court has given the cue to it, and it should have been continued instead of giving it a different interpretation. And as I said just now, it may be a high time to look at again the amendment to the Land Code Sarawak, whether in the light of Article through the prism of Article 13, yeah. The alternative, of course, is you can create a land tribunal instead of going through the civil court to determine whether an area is under the NCR or not. And this land tribunal must be properly constituted by people who understand the livelihood of the natives and so forth. Not some fellas who are foreign to it, because it's a different thing altogether. To be living as being considered as part of the land. If you look at some Australian cases, they said that, and even in Malaysia, it has been given recognition that the natives do not own the land; they are part of the land. Then how it can therefore be being taken as lightly? Okay, so I hope this will be given, and of course, upgraded is not UN, UP should be UP upgraded native court. Alternatively, maybe we can give it to the upgraded native court, which is being considered, give them the jurisdiction to determine what amounts to NCR and so forth, a little bit like the Maori court, the land court in New Zealand. High time to do that. With all due respect, I don't think the civil court should be interfering with NCR issues and all that. Leave it to a special tribunal, because you have to understand what actually it is, It is not just commercial law or whatever. It is it's a sui generis by itself. It is a special position by itself. Yeah. So hopefully that is another alternative I can think of. Yeah. Next slide. Okay. So I think that's basically my presentation. Sorry for taking so much time.
Yeah.
Sorry. Thank you. Thank you, bro. Thank you.
Yeah. Thank you. Thank you, Tan Sri. I think I mean, as you see, the state had took a step to try and to placate because of the reaction to TR Sandah. I think the policy decision to do something about it, and that's what the land code amendment was about, to try and ensure that there is some kind of protection. Of course, it becomes a different creature, as it were. Yeah. The other thing is, I think just one point, since you talk about the Borneo experience, I think the one important thing is that from the decision of Privy Council, they have always warned the judges against looking at things from a prism that is totally alien to the native interest, and to look at it as how the interest is on the ground. Someone has actually said there is a third body of unrecorded legal rules that are deeply rooted in a particular system, and that constitutes the mentality and the way of reasoning of the law, the way of building a legal rule. These rules cannot sometimes be verbalized. They form part of an unrecorded and unexpressed background to an outsider who cannot understand. Certainly, they cannot supplant. This is one of the main aspects of legal tradition, and it's something I think, particularly for native rights, is important to understand that there is a perspective which is quite different from just what you see in the written law. Now, with that,
that's why, Prof. That's the reason why I've my first third slide. I produced what the Datu Gopal Sriram said in Hong Leong, that the judges must interpret the law in a way that depending on what the society needs. Yeah. Okay. Thank you.
That there is a real need to have an on-the-ground kind of understanding, particularly in these areas. So with that, I think it's a natural flow into Dr. Yoge's presentation, where he will look at the common law. What exactly is the common law aboriginal title? Was it an application? Was there a misapplication of a common law native title in the case of T.R. Sandah? I mean, we know there is a growing and in fact established jurisprudence internationally. So are we applying it correctly? Dr. Yogesh.
Thank you, Buan. We've heard very strong words from Tan Sri Richard Malanjum. In fact, he did not dismiss. In fact, he said he actually talked of the possibility of the judgment of in T.R. Sandah, the so-called majority judgment, being possibly per incurium. Now, with that in mind, I would like to say that what I'm about to say is really not. It's not crying over spilt milk, as it were, or being a sore loser if you're their lawyer. You know, it's more than that, because the ruling in the majority ruling in T.R. Sandah continues to have practical relevance, because there are 6 appeals now pending before the federal court on revisiting T.R. Sandah. There's also a real likelihood that whether the common law, as in my view, erroneously interpreted in T.R. Sandah, will be then extended to the 2 other jurisdictions that have indigenous minority populations, namely Peninsular Malaysia and Sabah. So with that in mind, I'm going to spend the next 15 or say 14 minutes now focusing on the judgment of, on contending that the judgment of Rao's, Chief Justice Rao's, or President of Court of Appeal at that time, goes against the basic principles of common law, native customary rights, or native title as applied in Malaysia. Next. Right. So very quickly, we'll just look at a common law question at the federal court. It was question 1. It is whether the pre-existence of rights under native title, native laws and customs, which the common law respects, includes rights to land in the virgin primary forests, which the natives, here we're talking about the Sarawak natives, who are Iban by race had not felled or cultivated. So with that in mind, so it's important, since we are talking about the common law, to actually see what the common law position was prior to this decision. Next slide. 8 years before Tuai Rumah Sandah, the federal court had, in my view, authoritatively determined the fundamental common law principles as in the case of Mandeli bin Saleh. And I'm not going to read through everything, but I will highlight certain principles. And with these principles, then we will compare it with what was decided in the judgment of Justice Rouse. Now, fundamental principle is that the courts will assume that the crown or the sovereign ruler, whether it be the crown, the British crown, or subsequently the Sarawak state government, intends that rights of property of the inhabitants or native inhabitants are to be fully respected. And this is taken straight from Mabo, the case of Mabo from Australia. Now, the federal court also cited another Privy Council case. And it's very important to realize that the courts, again, will assume that the British Crown intends that the rights of the property of the inhabitants are to be fully respected, and the courts will declare the inhabitants entitled, and this was pointed out by Puan Rami, even though those interests are of a kind unknown to English law. And in respect of extinguishment of common law, the court held in Mandeli Saleh that such a drastic measure needs to be expressed in clear language and cannot be derived by mere implication. Next. Right. So, the fundamental common law principle, in my view, can be summarized in the statement in bold on that slide, which is a presumption. It will be presumed that native customary rights or orang asli customary rights throughout the Commonwealth that will continue to be legally enforceable unless they are taken away by plain and obvious words in legislation. Right? So in this regard, the federal court in Mandeli bin Saleh unanimously decided that the cases of Mabo and Calder reflected the common law position with regard to native titles throughout the Commonwealth. So it would be useful to look very briefly how these cases look at two aspects of that principle I just mentioned, which is first, the presumption of continued legal enforceability of pre-existing customs, and secondly, unless they are taken away by plain and obvious words in legislation. Next. In Mabo, the argument there, and you will find that this argument later will be repeated. It's actually repeated in the T.R. Sandah case itself. So the Queensland state government in Mabo argued that previously existing Aboriginal interests in ancestral lands continue after annexation only if they are recognized by positive or executive or legislative acts. Now, this is basically the doctrine of recognition. So the doctrine of recognition says that if there's a new sovereign, all previous rights are no longer valid, and only those previous customs that are recognized by statute or by executive act are afforded legal recognition. Now, this is the argument. This argument put forward to the state by the state government in the Mabo case. 6 of the 7 judges of the Australian High Court, which is the apex court, rejected this doctrine of recognition, and they opted for and followed a lot of cases, including Privy Council cases and cases from other jurisdictions, to say that it is a doctrine of continuity rather than a doctrine of recognition that applies. That is to say, when upon a conquest or a change of sovereign or change of ruler or change of government, it is to be presumed in the absence of express confiscation or of subsequent expropriatory legislation that the conqueror has respected private property rights and forborne to diminish or modify them. You can, as we are short of time, you can read the third bullet point as to the rationale for that. Because if those rights were to stop, it would, in short, that particular society that's taken over, where there's this change of sovereignty, would be lawless. It just does not make sense. And the common law recognizes this. So traditional title to land is not extinguished by the act of state amounting to annexation, but is presumed to continue. Next. In Calder, this is very short before we actually zoom in on what happened in TR Sandah. The same thing. The proposition that after conquest or discovery, the native peoples have no rights at all except those subsequently granted or recognized by the conqueror or discoverer is wholly wrong. Next. Just before TR Sandah, I apologize, just on extinguishment, the issue of extinguishment, it is quite clear, just as decided in Delhi, the power to extinguish, when one were to refer in Mabo and Calder, is a power, it is a power to be exercised following a clear and plain intention to extinguish native title. It cannot be, native title cannot be extinguished by regulation of the enjoyment of native title. For example, the Sarawak Land Code. And the burden is basically, if you look at Calder, the burden lies on the respondent in that case, which is the government of British Columbia, that it lies on the burden on the government to prove that there were plain, obvious words contained in a legislation taking away those customs. So in short, customs continue to exist under the common law until they are taken away by plain and obvious words in legislation. Next. Now we come to the crux of what I'm talking about today. Right? This is, in my view, of course, the misapplication of the common law in Tuai Rumah Sandah. And this comes from the judgment of Rao Sharif, PCA, as he then was, and with Ahmad Rao, Federal Court Judge concurring. Now, in TR Sandah, the state relied on the various statutes and orders claiming that the Pemakai Monoa customs that were laws that the Sarawak had never recognized and were not customs. Now, if you had been listening to me for the past 6 minutes or so, this is basically an argument for the application of the doctrine of recognition. So what essentially the state Sarawak, the government of Sarawak was asking the court to do was to reverse what was stated in Delhi. So Justice Rouse then held that the statutes and orders of proclamation made by the Raja and subsequently by the legislature had never appeared to have been recognized as customs. As such, they do not come within the definition of law under Article 160 of the Federal Constitution. This basically flies in the face of what was decided in Delhi. I think this was already suggested by Tan Sri Richard Malanjum, and just fleshing this out a little. Remarkably, Justice Rouse also cited the passage from Mabo number 2 with approval, which actually says that native title has its origin and is given its content by traditional laws and customs and must be proven as a matter of fact. In other words, these laws, what was referred to is laws, meaning traditional laws practiced by the native community rather than something a codified custom contained in written law. Now, this is the decision in Mabo, yet he cited that and did the opposite. Now, it is material to note here, very material to note here, that in the Mabo case, the Mariam people did not enjoy any express customary rights to their land. Statutory customary rights. So there was nothing in the statutes affording them recognition of their customary rights to their land, and yet the court recognized their pre-existing rights as recognized by the common law. The same can be said for Adong bin Kuau, because there's no recognition of customary rights in Peninsular Malaysia by statute. And the same can be said of the Nishga in Calder's case.
It's 4 o'clock.
So that is the other point I wish to make is that the judgment, I think, as I will not repeat what Justice Richard Malanjum said, but the judgment also cites Madeli, Adong, and Sagong, which are common law cases, with approval, leaving a huge gap in the reasoning, legal reasoning. And finally, before I move on to the dissenting judgments and my conclusion, I would say this, that it's not as if statutes are not relevant. Statutes definitely are relevant to determine the extent of extinguishment of rights rather than recognition of customary rights. And this judgment did the direct opposite. Next. Yeah. Since I'm running out of time. So what, and we can deal with this during the Q&A. If one were to look at the judgment of Zainon Ali and also Abu Sama Nordin, they have properly applied the common law as decided by Madeli previously and all other common law jurisprudence. But I just want to make one comment before I conclude on Abu Sama Nordin's decision. He essentially agreed with the majority based on evidence, right? But declined to answer the question 1 that I referred to earlier, but held, very importantly, and I'll read this out, it was submitted by the Sarawak government that this custom of Pemakai Menua and Pulau was not part of the common law, which is recognized in Sarawak. He actually then went on to hold that Ian Chin in No Anak Nyawa I referred to earlier, in the earlier talk, in No Anak Nyawa's case, Ian Chin had held that the common law as recognized in Sarawak came within the definition of law in Article 1602 of the Federal Constitution, and in my view correctly, the issue whether the plaintiffs is a matter of evidence. So the land customs effectively had been given the force of law under Article 160 through common law, through the common law, which is a source of law under Article 160. And I can explain what I mean if you're not clear about that earlier, the audience, anyone's not clear. Next. Yeah. I'll just say this because we can discuss this later on. There's an obvious chasm in the legal reasoning between Madeli bin Saleh and Tia Sandah, and even the judgments of Zainon Ali and also Abu Sama, Justice Abu Sama. And this needs to be reconciled because the foundations need to be clear, because in Sarawak, there is a complementary statutory regime whether or not Sandah has been correctly decided, the 2018 amendment from my study of the Hansard that recognizes, purportedly recognizes the pemakai menua customary equivalent, does not extinguish prior common law rights to such customs, but merely gives effect to common law rights, right? And I also wish to talk about, perhaps if there's time later on, that I think there are amendments, that there are limitations in the amendments, which which we can discuss during the Q&A, and those are in desperate need of legislative reform. One little comment about Peninsular Malaysia. Overruling common law principles in Peninsular Malaysia would necessarily involve legally justifying the reversal, right, of 20 years of domestic jurisprudence and risk a regression of customary rights back to the outmoded and regrettable jurisprudence of the early colonial era. But in the case of the Orang Asli, they do not have express recognition of these rights. So the impact of them on them would be far more serious. I'll just, I'll finish off and we can discuss more if there's time. Thank you, Juan. Sorry about the delay.
Thank you. Thank you, Dr. Yogesh. Because of time, we will rush on and move on to Dr. Gudiel. Dr. Gudiel, your work has emphasized the importance of traditional knowledge or traditional knowledge of indigenous communities. Often their knowledge systems may not be in written codes or in written legislation. How would you reconcile that with all this statutory regime? Yeah. Dr. Gudiel. I think you have to unmute yourself.
Okay, can you hear me?
Yep.
Yep, thank you, Dr. Rami and friends on the panel. Now, first, I just want to raise a couple of questions on the rather comprehensive way in which my preceding colleagues have, Tan Sri Richard Malanjom and Dr. Yogeswaran have dealt with the topic. I just want to throw out a few points that arise from their discussion before I talk about actual traditional knowledge and traditional knowledge. The first is, now if this pre-existed, if this, the rights, customs and usages established the rights of indigenous peoples and communities pre-existed the 1957 Constitution, and therefore, because of the definition of law in Article 160(2), have the force of law, customs or usage having the force of law in the Federation. They already had the force of law in the Federation when the Constitution came into existence. Then any law enacted after that would, under Article 4 of the Constitution, be inconsistent with the Constitution. And to that extent of its inconsistency will be void, which means you cannot really extinguish rights that have already accrued and are recognized as law on the day when the Constitution came into being. Now, the fact that Madeli and so on limit this, and over the years, ever since Raja Brooke came into Sarawak, for example, and started enacting legislation right up to the amendments of the National Land Code, which extinguished or abridged or impaired rights of indigenous communities, to that extent, are these enactments or laws that amend this not void, in very much the same way as the separation of powers doctrine, for example, which is not really clearly spelled out in the Constitution, but it forms the basic construct of the Constitution. So it cannot be extinguished, cannot even be the subject of amendment under the amending provisions of the Constitution itself. So that's my first proposition, whether this law, whether all these efforts to abridge, impair, amend the rights that had already subsisted and existed at the date when the Constitution came into being can at all be altered And my view is that there's a strong case to make out that it cannot be. Now, the second point I want to raise is this question of Article 5. We always view Sagong Tasi and Adong and so on, view these rights, they recognize indigenous rights to property, to usufructory rights, and so on and so forth, and then give compensation. But if you look at some of the pronouncements, it is not just a question of livelihood for indigenous communities. It represents life itself. It's intrinsically woven with the life support system. These rights are interwoven with the life support system, social being, cultural being, and so on. So it's life itself. I think there are clear pronouncements in Kajeng Tubik and a few other cases that it goes beyond just the question of them being able to access the resources that exist in the forest and so on and so forth. Now, if it is life itself, then we cannot deal with it as a matter under Article 13. We have to deal with it as a matter of Article 5. And the question that arises then is, can you therefore, just as in Sagong Tasi, when it involves matters that are intrinsically woven with the life support system, extinguish that by paying compensation? Now, this would be like authorizing, someone to kill someone, saying, yeah, I can be killed, but doesn't matter because life is worth so much. He was working, let's assess the quantum of damages payable to life. So I think this raises a very fundamental question. The third point I want to raise that arose from the discussion is when we deal with, I think Tan Sri Richard Melanjom raised this about the Borneo experience and so on. You must have Borneo judges dealing with matters that deal with Bornean experience relating to land, native rights, and so on. But should we not go one step further? And this is, I think, the problem that happened in Sandah. You have judges deciding the cases who have no sensitivity and understanding of what actually native customary rights means to communities. They cannot see the wider canvas upon which these rights are constructed. Now, so it is not just a question of having a Bornean experience, but it is having judges who understand what the concepts are about and what it means in terms of the intrinsic social, cultural, societal values to the indigenous communities itself. So long as you do not have that, then you will continue to have judgments like Sandah, in my view, because there is complete lack of understanding of the basic substratum or the basic foundation of indigenous rights. And then the fourth point I want to come to is traditional knowledge. You see, for example, now it is recognized under the United Nations Declaration on the Rights of Indigenous People, also under the Nagoya Protocol on traditional knowledge, accessing traditional knowledge associated with genetic resources and so on. The central role of traditional knowledge to the life, to the value and existence of indigenous peoples. I mean, it's very important. It is in the short period that I have, just to emphasize the fact that it is this traditional knowledge that has healed the world, that has clothed the world, that has fed the world, because it is through their knowledge systems. For example, the WHO acknowledges that 3/4 of the medicines that we have today are as a result of the lead provided by indigenous communities. So they have healed the world in that sense. The farming community, indigenous farming communities have provided through millennia, through the development of food resources. They have provided and fed us with they provided us with the bread basket upon which we feed today, and so on and so forth. So that's a very critical role. And now with climate change, the resilience that is required in dealing with drought and other drastic climatic changes, people are beginning to recognize that indigenous communities the traditional knowledge in dealing with this will come into very strong play in meeting these kind of clients. Now, traditional knowledge has, now it is being reasserted. So, and the traditional knowledge, the context within which traditional knowledge flourishes is, of course, being abridged because the land, the habitat, the language diversity and so on is being destroyed by modernization, by laws, for example, the land codes that are extinguishing the rights of indigenous peoples, and so on and so forth. But now there is some hope because internationally, for example, the Nagoya Protocol on access and benefit sharing of genetic resources and traditional knowledge associated with traditional knowledge associated with genetic resources is beginning to take some center stage in stating that we have to recognize these lifelong practices of indigenous communities established through customary practices, through customary protocols, through procedures, and so on and so forth. And that this is essential if we are going to meet the kind of challenges that the world faces. Traditional knowledge and the social, societal, proprietorial context within which within which traditional knowledge flourishes. Now, of course, there's beginning to be recognized that there is a limitation of state sovereignty. In other words, there is a carve out of traditional knowledge as being almost sacrosanct, which you cannot disturb, as it were, and that this has to be recognized, and therefore laws are beginning to be shaped. Even after the Nagoya Protocol, we have enacted a law in which some of us played some role in drafting, and it has become law that if you want to access the biological resources, genetic resources, and biological resources of indigenous communities or of indigenous communities and traditional knowledge associated with it, then there is a whole protocol, whole set of laws that require you to get access and share fairly and equitably the benefits that arise, so that at least this will then allow for the flourishing and continued sustenance and preservation of this knowledge. So we have states are beginning to move in that direction. Some very slowly, some more. Some resistance there is because in our country, traditional knowledge is associated with genetic resources, which is associated with biological resources, which is associated with land. And land is the preserve, the exclusive constitutional jurisdictional preserve of states. A lot of states resist this. And usually, traditionally, what has happened is that indigenous communities, through lawyers like Yogesh and so on and so forth, have been fighting against the state, against the federal government, and against states in trying to reassert, national native customary rights and related rights like traditional knowledge. But now I'm involved in a case that where under the previous government, the federal government itself has filed a case against the state government of Kelantan for breaching its fiduciary duty towards indigenous people within the state of Kelantan itself by carving out their lands, their rights in land to Musang King plantation owners and other orchard owners and so on and so forth. So this is an interesting development. I don't know whether it will be sustained, but this is one of the ways forward in which the context within which traditional knowledge flourishes, which is the habitat and the land, is beginning to be reasserted in new frontiers and in new ways. Whether this will continue or not, we'll have to see how it goes. But I think there are some openings, favorable climate beginning to emerge for assertion of these rights. And with that, I end my presentation. I thank you very much.
Thank you. Thank you, Dr. Gudiel. I think we are really looking at the societal context within which traditional knowledge will flourish, and that's related to land. And in that context, we're looking at even this practice, this custom of using the land, using the resources on the land is something that is part of traditional knowledge, I would say. And therefore, there is that little connection, that connection to what we are talking about. Can I just ask just one other question, just before I answer one of the, I ask you to answer questions that have come in. Where do we go? How do we go from here? What would be the step forward, as it were? Maybe in just one or two words from each of you, what do you think we should be doing in to move on, knowing very much that this decision in TR Sandah, because it is a federal court decision, it has such an impact on other decisions that are coming after it. And you know, how do we go, instead of doing what Sarawak has tried to do, is to try and cut, as it were, try and deal with the loss. But I don't know, what do you think? How would you recommend, or what recommendations or proposals would you give before I give some of the questions for you to answer? Tan Sri, maybe you have something to say first, and then Yogesh, if you would say something, and then Dr. Gudiel.
Problem, in what context you're talking about this? In proposal, in what direction you're looking at?
In terms of looking at land rights, and in terms of, let's say, recognition. I think the crucial thing here is recognition of their customs, and because, as you said, it is being recognized, but it is now being curtailed in some ways. So forcing people to try and find a way to get it recognized.
Then that's the reason why frankly, not that I don't have confidence in the civil courts, but in this type of situation, it'd be good, I think, if it's handled by actually a tribunal or even the upgraded native court, which is being proposed. And it'd be easier for them to understand what it's all about. But if you give us, Dr. Gudiel said just now, to guys who may not really understand, who has not got the spirit of what it is, and then I don't think there's much hope. So in my view, this has to be addressed. The forum must be addressed. It has to be taken care of properly first before we start discussing on other aspects. That's my view.
Thank you. Yogesh, what do you think? Do you have something to say? Unmute yourself.
Yeah. Thanks. Yeah, I think I'm echoing what Tan Sri has to say, and just adding on. We just take by just giving an example. If one were to look at the recent amendments to the Sarawak Land Code 2018, there's once again too much power given to the executive to determine the extent of recognition to be afforded to this native territorial domain. So there's no check and balance. So it certainly goes back to that. The second point I want to make, and I have three points very quickly, is this revisiting of TR Sandah. Apparently, comments from the bench have not been very encouraging. Not while I was there. I just understand that they say, "Oh, now you have an amendment to the Sarawak Land Code, and it's game over." You know, I just think it's quite unbecoming to make that sort of comment. And more importantly, the leave has been granted. So if leave has been granted, they should actually revisit and basically set the law in the direction that they think just. So this revisit of Sandah, I hope, produces some results, good results, but although I'm not too optimistic. But the final thing is just on the questions posed by Dr. Gudiel. It is a very good point. I think these questions should be posed in future cases because they take a different, a slightly different twist. And I think it's something that can be posed in future courts. And in fact, Tan Sri Richard also in Batu Bagi alluded to this extinguishment point. And I think those lawyers out there, and I know there are a few of you, this is out there, please take note of this, and hopefully you can pose this question and build an argument towards this extinguishment point. That's all.
Yeah, thank you, Dr. Yogesh. Of course, one of the arguments here was there was no, as you say, there's no real extinguishment of the rights there, and so it should continue. Dr. Gudiel, what would you?
Just very quickly. I think for some reason, especially since Yogesh has expressed the fact he's not very optimistic about the review of Sandah itself, I think, going through the courts, hoping for Sandah to be overturned may not be that easy. The law has become very fragmented. I think Tan Sri Richard Lanjong and Dr. Yogesh showed very clearly, Madeli and Niawai and so on and so forth, that some of it's at odds with each other. I think the best way to resolve this perhaps is, aside from us in each case that we come up trying to challenge, and I'm going to do it in the Kelantan case, to return to basal principles about the foundation of indigenous knowledge and indigenous land rights. What is the basic foundation, and getting the courts to come back to that basal principle. But I think over and above this, I think the time may be ripe for there to be a commission of inquiry that has got some expertise and people with sensitivity, legal people, and others, sociologists, anthropologists, and so on, who has got a good idea of the construct of native customary rights and their foundation, and to have a review like a law commission into NCR rights, and to really thresh out this issue in a very holistic way. That will, it might take time and require money, but I think we need to settle this once and for all, instead of having, in my view, judges who lack sensitivity suddenly coming up on the basis of some arguments and complete misunderstanding of the fundamental construct of indigenous rights. And I think this is what I would suggest, preferably a royal commission, but otherwise a law commission on indigenous people's rights. Thank you.
Thank you, Dr. Gudiel. We take note of that. The Royal Commission of Inquiry, I think, as you say, return to basal principles, the foundations of indigenous principles and indigenous land rights. I think that's really important. But just following on, there are a few questions here. I think we are given extra 15 minutes, so just to try and deal with the questions. No, we're supposed to finish right now, but we're given grace of another 15 minutes. Just to follow on from your statement, Dr. Gudiel, there's a question here directed to you and to Tan Sri. How would the judiciary encapsulate the sensitivities as to native customary rights? Would it need to be a precursor prior to the confirmation of a judge? If so, to what extent would that be applicable to non-native judges? I think that's a question from the floor.
If you ask me, it's a $1 million questions, but I tell you what, every human being has inside him, a feeling. If he has none of that, and he shouldn't be a judge. So sensitivities is inbuilt. And for those who want to hear native cases, I will say this, especially if you're non-native or you're from Semenanjung. go and live with the native first. For 1 month maybe. And then you understand what it is like and you appreciate life better. I think that's one way of approaching it, because I've read some material, even Australian judges, I think in Wicks or in Mabo, where they actually went to study the lives of the indigenous people there before they came up with their decision and so forth. I read somewhere article, I couldn't find it, but anyway, I've read it last time. And that's, I think, is important to be able to understand. So if you understand how they live, and I think in Nyawai case, in the High Court judgment, made it very clear why it is so important to understand the native way of life before you actually come to certain conclusions. This is the thing that I think is missing, and we need to address that. Thank you.
Yeah, so experience is also very important. Dr. Gudiel, did you add to that?
Yeah, just very quickly, I think that's an important point that Tan Sri has made. It's strange because when we want every court in the world, in the Commonwealth world, when they want to deal with commercial matters or they want to deal with patent rights or intellectual property rights, they make sure that that person understands, the person who's going to sit in the court, in the patent court, in the, knows the subject very well, has gone through a course, has gone through a whole host of experiences in relation to that. But when it comes to native customary rights, it's just any judge who can just come there and give his viewpoint on the run virtually. I think that doesn't make sense, because if for commercial matters, you need people who are experts and so on and set up those courts, then for this also, you must have judges who are well-versed in the sensitivities. And I like the Tan Sri's idea of them going and living with the natives. I've gone lived with the natives in Colombia, in the Amazon, and in a few other places, including in Sarawak, because I work with the Sarawak Biodiversity Center. But the point is, I think this is very important. We must have those judges deciding on matters that require an expert understanding. Then only sensitivity will develop. Then only they'll understand the consequences of their pronouncements. Thank you.
Yeah, thank you. The additional question to that is someone is saying that, well, the native courts are not very well regulated in terms of evidentiary burden. Maybe they don't have the learned judges. How do we draw a balance between the civil and the native courts in this regard? That's a very practical question and maybe an organization question.
Yeah.
Country.
We have to upgrade the native court. It's not as a presently, definitely is a no thing. No. We have to upgrade it first, in the same way as how they slowly upgraded the Sharia court, and I see no reason why it cannot be done. There are many qualified people who are quite well versed in the native customary law and native rights, customary rights and all that. They can be trained, or they have been already trained, actually, experienced with it, and they can come and sit. We have to look at how the Maori courts are being set up. I think we can. It's not a question of sending it to native court as it is today. No. I will be the first one to say no. That is not the right approach. That's my view. Thank you.
Thank you.
Just want to add to that one on examples. There are a lot of frameworks out there. In fact, in Australia, you have the Northern Territory had a very good land tribunal system, which is quite less formal, and they resolved most of the Aboriginal Land Title Rights Act claims in Northern Territory within quite a short space of time, relatively, and I think about a third of the state has land freehold, fee simple title given back to the native to the Aboriginal communities. So there are plenty of the Waitangi. Sorry, not Waitangi. The Maori Tribunal is one. There are plenty of models out there. It's a question of whether we have the will to do it or not.
Okay. Yeah. Good. Thank you. Just there are two questions here, which I think I can combine them. Does the TR Sandah decision has any relevance to native customary rights in Sabah? And secondly, how do you get around Sandah's case in pursuing, what about orang asli claims, for example? Okay, so I think Dr. Yogesh has already said something about orang asli claims just now, how it might affect orang asli. What about Sabah? Maybe Tan Sri, you may have an answer. Yeah.
Of course, in Sabah, we don't have the amendment as the 2018 in Sarawak, you know. But the TR Sandah, in a way, has actually caused a problem as well in Sabah because of the word custom not having the force of law and so forth. So it has implication when one decides the claim for native rights in Sabah. And we should be looking at it together. Sabah and Sarawak should look at it and address it. And it's not a Sarawak problem alone. Definitely no. And the other thing, of course, is if you look at the Sabah land, the Sabah land enactment, land ordinance, we call it here, is this. It has a very funny provisions when come to even to native titles and all that. And at one time, it was even argued that when that ordinance was passed in 1930, all the rights of the native gone with it, no more, it stops. It ceased to have to exist after that. It's almost like a cut-off point. Of course, we didn't agree to that, that kind of argument. And but it's still there. The issue of TR Sandah is still lurking. But so far, no case has been brought up, I think, in Sabah on that. So far. That's the position. Thank you.
Good. Thank you. Yogesh, do you want to say anything about orang asli again? Just do you have anything to add? Otherwise, we move on.
Yeah, just very quickly. I think I may have just answered. There's a bit of a repeat. I answered one of the questions by typing it out. There have been two cases subsequently after TR Sandah where the High Court basically did not consider TR Sandah on the basis that the questions the questions seemed to be limited to Sarawak, and Justice Raus did not expressly overrule Adong or Sagong. So as it stands now, it's fine, but the question will inevitably, I believe, find its way to the federal court in the future. And we'll have to address these issues.
Okay, all right. There are quite a number of questions that are coming in. Why I'm using that. There's one question again on judicial perspectives. It says currently in confirmation hearings and the US judge of Amy Coney Barrett, we have heard her views on originalist or contextualist or about constitution should be interpreted. And also how judges should not decide on policy issues. But when you apply her views to NCR situation, are the weak NCR decisions by our courts due to an originalist approach to interpretation of rights and a lack of robustness or activism in ensuring the courts assess legislation to ensure protection of NCR itself? Well, that's a very jurisprudential one. But anyway, Tan Sri, you may be able to answer that.
Well, I've followed Judge Barrett's conversation, but I think they are a different situation, you know. Originalists or positivists, sometimes we call them, depends. But to me, when we address the native customary rights and all that, I think it's best to look towards Australia and New Zealand. Yeah, I think they have better than other places because we have almost a similar situation, especially in dealing with indigenous people. And to me, the judges in Malaysia, they should be looking at that instead of trying to be positivist to such an extent as originalist, or they call it. Not that I don't agree to that, but it cannot be too much. There must be a halfway house, you know, and it's a halfway point. Okay, thank you.
Yeah. Thank you. Dr. Gudiel, I think you mentioned something on the UN Declaration of the Rights of Indigenous People. There's a question here that says, since we have ratified it, how can it be used in our court system?
Well, I mean, insofar as the government has recognized those rights, although it is not binding, it's not a convention to which we have, which is binding. It's what you call soft law. But at the same time, then we can argue that there is a legitimate expectation that as far as government agencies are concerned, that they will act consistently with the views that have been expressed by the government in recognizing those rights. So I think in that context, we can hold the government and its agencies to account to be consistent with what the government itself has declared to be to have adopted the rights that are embedded in this UNDRIP. And there's precedent for that, because in the case of Teo, the High Court of Australia said that insofar as the government had been a party to the Convention on the Rights of the Child, although that was a binding document, but then when the immigration authorities wanted to send back a Singaporean, I think, who was convicted of drugs, they said that the immigration authorities ought to have taken it into account, the legitimate expectation that the immigration authorities will abide by what they had agreed to internationally, which was that they would recognize the rights of the child. So they had to take into account the right of the child before deporting the husband to Singapore. So this kind of legitimate expectation, I think, can be the basis upon which we can make out a case that the soft law, although it's soft law, is something that government agencies must take into account in making their decisions. And if they fall foul of that, then I think there's a basis to say that they have acted contrary or irrationally, or not taken into account the relevant considerations.
Thank you.
Thanks.
Just one, considering the interesting pending case of federal government versus Kelantan, which you mentioned just now, what are your views on expanding the use of fiduciary duty to try and tackle NCR or NCL issues such as those that we have seen arisen from TR Sandah? I think you've already mentioned that. So maybe Tan Sri and Dr. Yogesh, what do you think?
Personally, I'm very keen on that principle, right? Fiduciary duties of the authorities of the government to take care. And I've been toying with that idea as well, because I've seen the natives in Sabah for the what decades have been literally the same, same situation, and nobody seems to care. So I'm very, very keen on that. I've been reading on that topic, and I've read some articles written by professors and all that on that area, and I think it can be done. Breach of fiduciary duty, so no harm trying it. And I'll be very glad if Dr. Gudiel can assist, because we need it. We need it to wake up those who are sitting at the corridors of power, to see to it that the poor natives are being given their dues.
Okay. Right. Just
Could I just add to that one?
Just add quickly and.
Just adding to the fiduciary duty point. The fiduciary duty point, of course, for those in the know, it has been held. There's a fiduciary duty to protect land rights, and for the government to protect land rights and not to act in inconsistency with the rights of indigenous people. That's from Sargong bin Tasi. There's been very little development in Peninsular Malaysia since then. Although there have been rulings of breach of fiduciary duty in Peninsular Malaysia, but it has not developed in the superior courts firstly. Second point I want to make is that it's very rarely pursued in Sabah and Sarawak. It's quite surprising that the lawyers in Sabah and Sarawak have not pursued this fiduciary duty point, because it's something that they should do in the future. And Tan Sri Richard has also referred to that in his judgment in Batu Bagi.
Yeah.
He has referred to it in Batu Bagi.
Yeah.
Yes,
So
just,
maybe
Dr. Ami, just to add quickly to that, we are exploring, of course, this is our basis of our claim in the Kelantan case, but we are also adding another dimension, which is there is beginning to be an interest in the question of the thought of inducing a breach of fiduciary duty. So there is a growing, emerging concept that there is such a thought. It has not been established yet, but we're going to explore this, and there is some writing on it that it's in fact is a thought that you could go on. It's not just a question of. So this will be interesting. That one of the viewpoints we're raising in the Kelantan case.
Yeah, well, interesting. That's just two last questions very quickly. From your presentation, Tan Sri, I observed a disconnect in requirements of IGC on the Borneo experience and the Court of Judicature Act 1964. It doesn't cater for this. Can the Court of Judicature Act 1964 be amended to cater for this requirement?
Yeah. That was one of, it was on my plate when I was still there, but unfortunately time did not permit, because I would have wanted it to be expressed, you know. But nevertheless, as I said, the Malaysia Agreement and also the IGC, no doubt they are not part of the Constitution or whatever. As done in USA, the judges, even in the Supreme Court of USA, referred to the Declaration of Independence when trying to understand the Constitution. Yeah? It has been referred to quite a number of cases. So there is no reason why, when come to Sabah and Sarawak and interpreting the Constitution, that those two documents must also be considered. It must be factored in, you know, instead of just being put aside and say, well, this is a historical piece of paper. I don't think that's the right approach. And Tun Zaki, I think in Tofil has made that very clear, and even in Sagumar's case. So that should be continued. That these two pieces of a document, very important document, should be the guiding light when a judge interpret to understand the Constitution, the federal Constitution, especially which affects Sabah and Sarawak. And that's how it is. It's not in a way to be a second piece of legislation. No, not at all, you know. But let these two documents be the guiding light. That's how it should be looked at if I were to interpret the Constitution. That's how it should be, in my view. Thank you.
I think Dr.
Thank
Rami,
you very much.
just to quickly one liner on that, and that is nowadays is acknowledged very clearly in interpretation of statutes and especially the Constitution, that we can take into account the history, the background, and the context within which that particular provision arose. So that allows us to take into account, for example, the Malaysia Agreement and the IGCC and so on. And IGCC has, in fact, as Tan Sri noted earlier on, been actually used in some of the cases, has been applied in some of the cases to interpret provisions of the Constitution. Thanks.
Yeah, thank you. I think our time is we've really gone beyond the time that's given to us. But I just wanted to read a statement from our colleague as well, Prof. Shad Faruqi from basically sent this message to say, I agree with the learned speakers that the doctrine of recognition is totally at odds with the idea that human rights is inherent. They do not depend on the charity and generosity of the state. Native rights being pre-existing cannot be extinguished. If they are, Article 13 will apply. I think that's totally agreeing with the speakers today. I think we've answered most of the questions. There are one or two questions from the same person on anonymous attendee, but I think we have answered most of the this question. I don't know, because it's talking about IGC and Malaysia agreement. I think we've answered that.
I think we have to end now, because we got.
We need to end. Yeah. So
Alright.
your questions have been answered. And we want to thank all the speakers for making time. Thank you so much for being here with us. And must say thank you, Yorick and Raymond, for doing the technical part and the struggles we have to go through, but we've done it. And thank you so much. And thank you.
very much.
Thank you,
Thank you.
everyone. And thank you
Thank
for
you.
attending.
Thank you and goodbye.
Thank you for
Bye-bye.
listening. Thank you for listening. Thank you for
Thank you.
listening to everybody. Bye bye.
Bye-bye.